Registry Matters is an independent production. The opinions and ideas here are that of the host and do not reflect the opinions of any other organization. If you have problems with these thoughts, FYP.
Recording live from FYP Studios East and West and more West, transmitting across the internet. This is episode 306. Whoever did the show notes did not update that, so I'm glad I caught it. 306 of Registry Matters. Good evening, Chance. How are you tonight?
I'm very well. Thanks for asking. Thank you.
And how long have you been practicing law? Was it just shortly after the year one?
34 years.
34?
Yep.
Have you always done criminal?
Always.
Really? Like at a law school criminal defense?
Well, yeah. Yep, you're a criminal.
Man, okay. And everything's good over on that side of the world?
Oh, everything's just beautiful. Yep.
Larry always has some kind of funny little quip to share. Anything you want to share before we move on?
Well, have you gone through all your intro?
Well, no. I was waiting for Chance to give me some kind of quip before I went over to you.
Okay, no, I don't have anything funny other than I think the episodes are
Wait,
not correct.
I wasn't done with Chance yet. Chance, do you have anything to share?
Well, I was just going to mention that, it's going to be very, very difficult for Larry to find anything funny about anything we're talking about today. But we'll see. We'll see if we can make you, Andy, think it's funny.
I doubt it. All right. Well, just to back things up, it's episode 305. Somebody put something else somewhere else. Anywho, 305. Welcome. Larry, how are you tonight?
Doing awesome. Glad you could have me back for this final episode.
Final? Okay. There's this podcast
That's not
that I listen
funny?
to.
Okay.
No. I am so busy right now that if we said we were done, I would be like, thank you. But there was this other podcast I listened to. They've been going on for, I think, 19 years, and they were going to stop when they hit 999, but they have decided to go past it. So we're not quite there yet. We can't stop yet.
I see.
All right. Well, like, subscribe, do all those things, arrow buttons on YouTube and all that stuff. Now, Larry, what are we doing tonight?
Well, we have a case from the United States District Court for the Middle District of Alabama. It's 162 pages, and I know you've read it completely, but I have not.
I've memorized it.
We have a case from the Pennsylvania Supreme Court that I can't pronounce, so I pawned that off on Chance.
Torsilieri.
If you say so. Then we have a short California corner segment with Chance Oberstein. And if time permits, we have at least one thing. No, actually, we took those out already, but we do have a funny that I think I'm going to get into, and we carried those other two over to the next episode about false accusations. But my guess is that we need to get going because this is a lot of content.
We do. We have to move along. And you're going to start things off with something about Larry's general rules?
Yes, indeed. I have a general rule, and I'll get straight to the punchline before I read the script. The punchline is, if you have had the good fortune of all the systems breaking down and you benefiting from all those systems breaking down, don't apply for a passport, a U.S. passport. Okay, so this story is about a Melrose, Massachusetts firefighter has been arrested and charged with stealing the identity of a dead man. A federal investigation has found that he has a criminal history that includes stealing money from a firefighters union in another Massachusetts town. That's where he stole the money. According to the federal affidavit, it was facial recognition software that determined that this man had two driver's licenses with two different identities. But even still, he was able to go on to graduate from the State Firefighting Academy and get a job using the identity of a teenager who died over 20 years ago. He became the focus of a criminal investigation after he tried to apply for a passport last year. His birth certificate and driver's license matched the information of a 13-year-old who had died in Boston in 2022. Federal investigators believe this man is really Trong Nguyen, a former Norwell firefighter who was convicted of embezzling thousands of dollars from the Norwell Firefighters Union in 2010. Now, as a result of that conviction, he was ordered deported. my guess is that he contested the deportation order and agreed that he would appear in court at his hearing, and he never appeared, and he's been roaming the United States as a person facing deportation. Then, with that fake identity, he managed to win the lottery again of getting a second job with a firefighting outfit. He was able to skirt whatever automated fingerprint identification that should have caught on the background check, and he was able to get a job, fairly cushy job, in Melrose, Massachusetts, and that wasn't good enough for him. He had that itching, burning desire to travel internationally, and he applied for U.S. passport. I'm not the smartest guy, but I would suggest to you that the U.S. government probably is integrated into every picture database that any state has. I would just about guess that every database that's out there, from motor vehicles to arrest records, that the federal government has that integrated into their systems. They're going to catch you folks. So don't apply for anything under a fake identity. Those days are behind us.
Would this apply to voters too?
What do you mean? Would it apply to
Well,
voters?
There are people that claim there's rampant voter fraud. And the media outlets that I listen to say, yes, maybe someone voted here, maybe someone voted there. Not to say that there is never a fraudulent vote, or someone may be voting twice, they moved, they don't remember that they voted, etc. But wouldn't this fall under those things of, you fill out your voter registration card? It would be pretty easy to go scour the interwebs and these databases to find if the person is registered to vote somewhere else?
That is, in fact, what they do. That is, in fact, what they do.
So wouldn't it be pretty hard to... It's pretty labor intensive, too, to go vote here, vote there, go vote here, go vote there.
Well, in my opinion, now I worked for a person who was the former director of elections for the state. And he has vast knowledge of how things work. He's still an election consultant. And that is what they do. It is exceedingly rare that a person votes maliciously twice. They may vote out of their precinct because you're tethered to a precinct and you move past a deadline and you go vote. Or with early voting, people end up dying. People actually die after they voted. I know that shocks some people, but they die. And after they've voted in that 30-day window, 28 days, whatever it is from state to state, people die. And they find out, those who want to propagate the myth about all these fraudulent votes, they find a list of people that were dead that voted. But they were, in fact, most of them were alive when they voted. I mean, this is all...
Most of them?
This is people who have nothing but fear-mongering on their minds to perpetuate this crap about massive voter fraud. But I mean, to each their own. In a free country, you can make false assertions if you like.
Got it. And so what's the short version? If you're trying to stay below the radar, don't file for a passport? Would that be what you're trying to say there?
That's my basic point. Don't apply for anything anymore using a false identity, because the photos are matched and the software recognition is pretty good, as I'm told. Meaning that they're going to discover that you have an image in the system that's in a different name. And then this man is facing 10 years for the passport fraud, and I think they said 5 years for the immigration violation, because he's no longer a legal immigrant. He was already deported. So he's got 15 years in the pen, and then he'll get to do a lot of traveling, but it won't be the kind of traveling he'd like to do.
They're going to send him back to Vietnam, you think?
That's what they're going to do, yes.
All right. Chance, I'm sure you have something insightful here.
Dead man voting? I don't know. Man.
All right. Well, then we shall move on to main event number 1, I guess. We did put this off last week because I think it came out just right before we were about to record, and I was traveling, and it was 873 pages. So while I was traveling, I was able to read it all, Larry. And so I was hoping that between you and Chance and everything that we would be ready to discuss this. Are you ready?
Not really, but we can try.
All right. Well, so they challenged various aspects of the ASORCNA, which is ASORCNA, which is the Alabama PFR registry, and Community Notification Act. They couldn't leave it just kind of short, could they? Like ALSORNA or something like that. They couldn't go short. They had to go long. But I do recall that we've discussed a case named McGuire before. Is this the same dude?
I think so. You're talking about the person who had no obligation to register in Colorado.
Oh, this dude. Okay.
And he moved to Alabama, and his brother, who is an attorney, the attorney advised him to go see the sheriff in Alabama to make sure that he had no obligation in Alabama. Sounds like something Chance would have told him to do. And the sheriff detained him for several hours while they were retrieving his conviction from information from Colorado. And they told him after they did all that, they said, "Boy, you done messed yourself up. You got to register, and if you don't get registered here today, we're gonna file charges on you." That's what they said.
I do remember the guy. I like the scenario of the guy that went to Colorado, came from Colorado to Alabama, and was like, "I don't have to register. Hey, folks, do I have to register?" "Oh, yes, you do." He could have just kept his nose clean and never told anybody. However, anywho, the opinion is 162 pages long. Have you read it?
No, and I don't plan to.
Slacker.
So I can say the opinion cites 3 related opinions sharing the name McGuire. In a separate case dealing with ex post facto clause challenges to Alabama's PFR registration, the district court tried the case and entered an opinion in 2015. And we talked about that one at some point. The opinion is referred to, for purposes of this show and for this opinion, as McGuire 1. And for those who want to figure out how to find it, the citations there. And then there was ultimately that opinion, that decision was vacated in part on remand from the 11th Circuit. And then I think that one we're going to refer to as just McGuire. And then finally the court's opinion in this case, as this went to motion to dismiss stage, is referred to as McGuire 2. So this case we're talking about is McGuire 2. We've got McGuire 1 from way back in 2015, and then we've got simply McGuire, which was the 11th Circuit's opinion on McGuire 1. So is that clear to you?
About as clear as mud, one might say. So if we can start by discussing your favorite point, which is, of course, summary judgment. And the court stated summary judgment is appropriate where the pleadings, depositions, answers to interrogatories, admissions on file, and any affidavits show that there is no genuine dispute as to any material fact, and that the moving party is entitled to a judgment as a matter of law. Should this case have been decided by summary judgment?
Probably not. But however, in view of existing precedent from the 11th Circuit in McGuire, remember that's one of the names, it probably wouldn't have made any difference in the end because of the precedential value of that.
Well, would you do me the kind favor and tell me what provisions were alleged to be unconstitutional?
Oh, sure. They threw everything with the kitchen sink. They went after the residency provision, which is Alabama Code 15-20A11. They went after the employment provision, which is Alabama Code 15-20A13. They went after the lording provision, Alabama Code 15-20A17. The ID provision, 15-20A-18. And the internet dissemination provision, which is Alabama Code 15-20A8. They threw up everything to see what was going to stick.
Aren't those all like legitimate complaints, particularly for someone living down there in Alabama?
Yes, but you've got to build an evidentiary record below to show how these things are unconstitutional. Something doesn't become unconstitutional just because you say it is. And very few people, like for example, the employment provision, you say, I can't find a job because of this. Well, you can say anything you want to, but you've got to prove that because the burden is on you. And when you're dealing with facts, the courts are going to consider facts to be what's been stipulated to by the parties. And I'm very doubtful that the Attorney General of Alabama is going to stipulate to a fact that can become the law of this case that the employment provision under Alabama Code 15-20A13 is what keeps you from getting a job. So therefore, you need to build an evidentiary record below when you're going after all these things. So there's nothing wrong with throwing the kitchen sink at things, but you actually need to be ready to put on a trial when you throw the sink at everything.
I've heard someone recently saying that this was a sham trial, a kangaroo court, and unconstitutional charges, and so on and so on and so on.
Well, I've heard of that, but I don't know if it's on topic here, but I've heard of that, yes.
It's certainly not on topic, but I've just heard someone mentioning it recently. All right, well, anyway, this has been quite a journey. The court stated, all told, the briefing, not including exhibits, is over 650 pages. Now, 4 years, 5 complaints, a motion to dismiss opinion, the 11th Circuit's McGuire opinion, a developed record, and well over 1,000 total pages of briefing into this litigation. The motion to exclude and dueling motions for summary judgment are before the court.
Yes, it has been going on for many years, and that seems like a lot of documents and a lot of a record. But remember, who bears the burden of proving when you're going after when you're going after a declaration of unconstitutionality? It's not that you don't like it, it's what you are able to prove. You've got to be able to prove these things that you're alleging. And I'm not sure they did that. And since I haven't read all 162 pages, I can't tell you what all's in there, but I'm not sure they did that. It's been going on for many years, this case has, or some variation.
We're going to have to find someone that's willing to read these pages.
Indeed.
But ultimately, though, I'm kind of confused. Though. The opinion states all plaintiffs bring the same 4 facial constitutional claims. Number 1, First Amendment challenges to Alabama SORNA thingamajigger residency provision. Number 2, 14th Amendment void for vagueness challenges to the aforementioned thing that they call it, the ASORCNA's employment provision. First Amendment compelled speech challenges, ex post facto clause challenges to residency and travel provisions. Meanwhile, KLL. What is KLL?
That was the initials of a person who didn't have full disclosure.
Okay, that's cool. All right. Meanwhile, KLL alone brings 3 additional claims: a 14th Amendment void for vagueness challenge, a First Amendment compelled speech challenge to their internet dissemination provision, and 14th Amendment selective enforcement challenges. Did this confuse the court?
Well, having never been a judge, I don't know that it did, but I have learned enough from interacting with judges privately that they get a little bit perturbed when there's so much thrown into a case, and it tends to distract from the core issue of the case. And Chance have 34 years of practice. He could probably help explain what I'm trying to explain more eloquently about throwing too much before court.
Well, all I say is that the kitchen sink approach is not appreciated. Yes, I agree with Larry. They like more of a targeted type of case where, the issues are pretty well defined.
Well, we kind of duel back and forth, Larry, on which state is the worstest as far as the registry goes. So how bad is Alabama's registry?
Well, it's bad. The court stated, quote, ASORCNA is one of the most comprehensive and debilitating sex offender schemes in the nation, affecting every area of plaintiff's post-conviction existence. According to the court, Alabama's law has 48 provisions, each of which contain dozens of affirmative duties and provisions. And then they cite you to the section of law. Many of these provisions reference and interlock with each other, often requiring 3 or more cross-references before the contours of a given provision become understandable. Now, Chance, can you? I know Annie won't, but can you admit that that's funny, that you have to do all that to figure out what it means?
Oh, I wish I could say it's funny, but it's not. It's not funny. It's a landmine of and what is it a landmine of? Failure.
So Alabama SORNA's 48 provisions cumulatively touch on virtually every aspect of registrants' daily lives, where registrants can live or work, who they can live or work with, where they can volunteer, who they can volunteer with, where they can go and for how long and for what purposes they can go there. The official identification bears a code labeling them as PFRs. Their personal information is published on the Alabama Law Enforcement on the public website. Now, folks, I know you love your conservative politicians, and they tell you how much they believe in individual liberty. But yet, this is the same state, among a couple of states in the Bible Belt, that made it illegal for a PFR to live with their own child. And that was challenged in the Abernathy case, which I think we talked about around in January, where that was put on hold by one of these lifetime tenured, pointy-headed federal judges. How is it that these politicians who claim that they believe in individual liberty and freedom would intrude this much in people's lives? Would you ask them that next time you vote for them, how they can square that? Because I don't see how that squares up.
And in all that you just spoke about, you only scratched the surface, though. For the duration of their lives, registrants have to appear in person before local law enforcement every 3 months to confirm their registration information, name, date of birth. Like, why do you have to confirm your date of birth? It doesn't change last time I checked. Address of each residence, name and address of any school, name and address of any employer, vehicle information, and frequent location where that vehicle's kept, any telephone numbers, any email addresses, any monikers used in internet communications, a current photograph, a physical description of themselves, fingerprints, palm prints, DNA, butt prints. I think they're going to check your junk like they did Michael Jackson, and the list of internet service providers used, and so forth. The plaintiffs concede some of their claims would fail. But which claims were abandoned, though?
Well, in count 4, where the plaintiffs had contended that Alabama's residence restriction provision and travel provisions violate the ex post facto clause of the Constitution, in their summary judgment briefing, the plaintiffs conceded these claims based on McGuire, which is the case from the 11th Circuit, and that holding, and McGuire holding that residency and travel provisions do not violate the ex post facto clause prohibition against retroactive punishments. Similarly, KLL conceded his claim in count 5, which alleged that defendant Marshall was selectively enforcing provisions against him in violation of the 14th Amendment. That was abandoned. Accordingly, judgment was entered in favor of defendants as to all claims in counts 4 and 5.
And the claims related to the initials person, KLL, those are gone? Is that right?
Correct, yes.
Is there any good news in this case?
Well, yes. The court stated ASORCNA largely survives the constitutional attacks lodged against it by plaintiffs in this case, but it does not survive completely. ASORCNA's residence provision, Alabama Code 15-20A11, 11A, and 15-20A11D, is facially unconstitutional under the First Amendment. So
please expand on that. Is that like super good news? Like they cannot, under a First Amendment challenge, say that you can't live here because you have a First Amendment right to live somewhere?
I am not able to parse out all they said in that 162 pages, but they did score a victory on a facial claim. When you prevail, something's facially unconstitutional. That means unless this is overturned on appeal, that you can no longer do whatever it was they were doing. So yes, there was a victory, but I can't parse out all the details of it.
And can you remind me, where does this go next?
Well, what happens next is I would imagine that there will be an appeal to the 11th Circuit. I cannot fathom that the Attorney General will concede any part of the Alabama statutory scheme is unconstitutional without filing an appeal. So I would imagine that the parts that were declared unconstitutional will be challenged, and I would guess that the plaintiffs may want to file an appeal, but I'm doubting. I think the appeal will actually come from the state because they're not going to want to be, they're not going to want their statutory scheme to be struck by the courts. I think the appeal is very likely.
And are you optimistic about such an appeal?
This case is so convoluted I could barely follow it. But as I said, I'm expecting the state will appeal because they seldom accept trial courts declaring a statute unconstitutional. And again, we have an attorney in here. Trial judges are on the low end of the food chain. And since an attorney general has a duty to defend the laws of the state, they are just not going to let some mediocre, even as a federal judge, they're not going to let a federal judge strike their statute without fighting. I would be very shocked if they don't challenge this on appeal.
Chance, do you want to respond to that?
Well, I think I'm going to in just a moment, because I'm going to talk about what happens when a state declares a statute unconstitutional. And it's really interesting that Larry says that, because this is a case in point.
Well, I want to ask, though, if, let's just say hypothetically, that this does get to the 11th Circuit and they affirm this, the residency restriction pieces of it. That's the 11th Circuit, and that applies to Alabama, Georgia, and Florida, if I'm not mistaken.
Correct.
Would that rule all of those residency restriction schemes null?
Well, if your team of legal experts were prepared enough to tell you what all that was found to be unconstitutional, but whatever was in that they struck, it would be applicable to every state, every situation in those 3 states in the circuit. It would be the law of the circuit, yes.
Well, that's pretty amazing. If that does happen to go that way, that would be fantastic for a whole mess of people. All of Florida is off limits pretty much for people to live.
But you got to remember, people tend to overread these decisions. We just did an episode last week where people in Tennessee wanted to overread the 6th Circuit in Doe versus Snyder. Whatever this is, we'll probably try to double back on the next episode and see if we can figure out exactly what element of residency restrictions were struck. But don't read too much into this. People want to say that courts have done things that they have taken actions they haven't taken. And it's like, no, that's not what the court said.
Gotcha.
Are you a first-time listener of Registry Matters? Well, then make us a part of your daily routine and subscribe today. Just search for Registry Matters through your favorite podcast app, hit the subscribe button, and you're off to the races. You can now enjoy hours of sarcasm and snark from Andy and Larry on a weekly basis. Oh, and there's some excellent information thrown in there too. Subscribing also encourages others of you people to get on the bandwagon and become regular Registry Matters listeners. So what are you waiting for? Subscribe to Registry Matters right now. Help us keep fighting and continue to say FYP.
Well, now we turn to the Commonwealth versus, all right, say it with me, Larry, Torsilieri.
Torsilieri,
where the Pennsylvania Supreme Court addressed the constitutionality of Pennsylvania's PFR Registration and Notification Act, otherwise known as SORNA, revised Subchapter H. Hey, Chance, I think I need to, we need to have someone switch hit, I guess, for Larry. So are you ready to continue with this?
Yes, I'll do that. And now that you pronounced Torsilieri, I'm going to follow your, how you did that.
That's how I've always heard it pronounced, I think, unless I have that wrong. But anywho, so dude from Pennsylvania. So what is this case about?
Well, it's about what happens when a state declares a statute unconstitutional. And this is a good context, a good case in point. Here's a quick summary of the case. George Torsilieri was convicted of aggravated indecent assault, but acquitted of sexual assault in the great state of Pennsylvania. As a result of his conviction for aggravated indecent assault, Torsilieri was automatically categorized under Subchapter H of SORNA as a Tier 3 sexual offender. Now, this designation subjected him to lifetime registration notification, and as you've discussed before, this bled into every aspect of his life. During the same time, the Pennsylvania Supreme Court decided Commonwealth versus Muniz, holding that the registration notification provisions of the then applicable SORNA statute were in fact punitive. Oh my God. So,
surprise.
Okay, that's a surprise. Now, the court concluded that these punitive provisions violated the constitutional protections of Pennsylvania's ex post facto clause, and when applied retroactively to sexual offenders convicted before December 20th, 2012. Okay, so what that means is the effective date of SORNA. So the General Assembly, then acting in response to Muniz, enacted Act 10 of 2018, which amended SORNA to address the constitutional shortcomings found in Muniz. In doing so, the legislature divided the registration statute into 2 chapters. Subchapter H, at issue in this particular appeal, was applied to sexual offenders who committed their offenses on or after December 20th, 2012, and thus to whom Muniz's prohibition against retroactive application of SORNA did not apply.
And I guess we talk about what kind of vehicle was used in other cases. What vehicle did Torsilieri use to challenge his tier designation? And what was the basis of his legal challenge to Subchapter H?
Well, Torsilieri filed a post-sentence motion in which he alleged that the registration notification provisions of Subchapter H violated his due process rights under the Pennsylvania Constitution. I know Larry likes that, including the contention that the legislative underpinnings of Subchapter H were empirically false. According to Torsilieri, the registration and notification provisions rested on SORNA's stated presumption that sexual offenders are, as a class of individuals, dangerous and pose a high risk of recidivism, justifying registration and notification provisions so as to protect the public. And additionally, Torsilieri asserted that the statute was punitive and unconstitutional as it was violative of the separation of powers doctrine, constituted a criminal sentence in excess of statutory maximums, of which was not found beyond a reasonable doubt, and was inconsistent with the prohibition on cruel and unusual punishment. Like, what else could it be thrown in there? But anyways, that was the vehicle, and that's what he alleged.
And with all that, did the court buy any of all that mumbo jumbo stuff?
Well, surprisingly, it certainly did, and in a big way. And this is really interesting. The Chester County Court of Common Pleas declared Subchapter H of SORNA unconstitutional as violative of his substantive due process rights. The trial court also determined that the registration and notification provisions constituted punishment. Amazing. And thus violated the separation of powers doctrine by removing the trial court's ability to fashion an individualized sentence. Finally, the court concluded that Subchapter H violated the federal and state proscriptions against cruel and unusual punishment and vacated his registration requirements. They were no more. And of course, the Commonwealth appealed to the Pennsylvania Supreme Court. Then, the wonderful Supreme Court, in a divided decision, a majority of the court vacated the portion of the trial court's order declaring the registration notification requirements of Subchapter H unconstitutional and remanded it back to the trial court for further proceedings, whereupon the trial court again struck Subchapter H as unconstitutional. And once again, the Commonwealth appealed directly to the Pennsylvania Supreme Court.
And so that went to the Supreme Court. They kicked it back down. Then they ruled almost the same again, and it went back to the Supreme Court. So what was the final result of all this legal drama and ping-ponging?
Well, since the lower court didn't get the hint, based on its own analysis of Mr. Torsilieri's claims and issues, the Pennsylvania Supreme Court found that Mr. Torsilieri failed to meet his burden to establish that Subchapter H's irrebuttable presumption that sex offenders pose a high risk of reoffense is constitutionally infirm. I don't know how they got that, but furthermore, they concluded that he failed to meet his burden in demonstrating that Subchapter H constitutes criminal punishment as well. Now, the end result was that the Chester County Court of Common Pleas order finding Subchapter H unconstitutional and relieving Mr. Torsilieri of his duty to comply with Subchapter H was reversed by the same court that granted relief, wait for it, in Muniz. For those who really want to understand the court's reasoning in coming to this conclusion, their analysis starts at page 22 of their 56-page opinion.
Wow, that's a long opinion, isn't it?
Well, it's quite an opinion, but they got to where they wanted to go, where they wanted the lower court to go, and then of course, totally reversed the lower court, and as a result, Mr. Torsilieri has to register, and is going to be designated exactly as he was.
And as far as I understand it, them going to the Supreme Court of Pennsylvania, is there the next court up? Can they somehow go to a circuit court or to the Supreme Court?
I think it's done. I think it's done. I mean, I suppose they could hop, skip, and jump up, but I again, am in agreement with Larry here. Courts, especially Supreme Courts and those above, okay, they are loath to just rest on what a lower court decides, and sometimes does this kind of thing in order to hint fall into line here so that we don't have to do much more. And when that doesn't happen, they do it themselves, and here we are.
So I would say that if you read very carefully, they concluded that he failed to meet his burden in demonstrating that subchapter H constitutes criminal punishment as well. Folks, before you can get to cruel and unusual punishment, you have to assert and prove that the registry is inflicting punishment. Since the state will never stipulate to that, you're going to have to put forth that evidence in a trial setting and call witnesses and have them certified as experts. And when you did this post-conviction motion, I don't know that process in Pennsylvania, but my hunch is that that forum and that process wasn't really set up for you to build a strong evidentiary record. So now what we have, thanks to this brilliant litigation, is we have an undercut of Muniz to some degree, because the same court now has said, well, not so fast. Yeah, we said that in Muniz, but the legislature did some tinkering 6 years later, and we don't see it the same way we did. So this will invite legislation in Pennsylvania to add some of the provisions back that were previously stricken. And that's the danger of this type of litigation. And I don't profess to be an expert, but I am enough of a reader to figure out that the continuous consistency, what we see, is that they concluded that the challenger failed to meet their burden. And those are all words I can understand. And I'm thinking if I can understand them as a high school dropout, I'm surprised that lawyers can't understand them with massive amounts of education, because that's the consistent thing we see over and over again. And if I'm a lawyer, I'm going to say, I've read 37 decisions, and they all say one thing consistently: failed to meet their burden. How can I overcome that in my case? Chance, why don't lawyers have those conversations with themselves?
Yeah, it's anybody's guess. It's anybody's guess. Don't know.
Well,
shall we? Oh, go ahead, Larry.
Well, I was going to say, when you have a client come to you, sometimes you have to tell the client unfavorable news. We're doing this in the wrong venue. We're using the wrong vehicle. You're not the right challenger. You're not a sympathetic individual. And people don't want to hear those things. They want to. I've had attorneys that have asked me to help them, and I look at where they are procedural, and I say, you're using the wrong vehicle. You can't win in this vehicle. You're using the wrong process. Well, but the prosecutor didn't object. I had one in Michigan. He filed a removal petition for a person who was statutorily excluded from removal. I said, how do you plan to overcome the statute that says this person's not eligible based on this offense? Well, the prosecution didn't object. I said, but the court doesn't have jurisdiction to grant this, even if the court is inclined to do it. And if I'm the state of Michigan, I'm going to appeal. Well, the local prosecutor doesn't. I said, but yeah, the AG's office is going to come in and pick up the appeal on this. And lo and behold, that's what happened. And I don't understand this stuff because I have no education and I can figure it out. And people who have years and years of education can't figure it out. And Andy says that I'm being, what do you say when I tell you that I don't understand these things that are easily understandable, and you get mad at me to saying that that they're not that easy to understand? What is hard to understand about they concluded he failed to meet his burden? What is hard to understand about that?
Oh, so many things, Larry. And just because someone doesn't have formal education doesn't mean they're not educated. Some people have lots of formal education and they're still morons.
Well, now that I will agree with you on.
Just because you spend
Yeah.
$100,000 and got a piece of paper doesn't mean you're all of a sudden smart.
I will agree on that one. But yes, the consistent failing we have is we don't have enough evidence in the record. And the burden is always on us when we're challenging a statutory enactment. It's presumed constitutional.
I have to ask the two legal minds here a question about something Pennsylvania specific that has this right to reputation. And I guess the way that I want to frame it is if they were doing a normal constitutional challenge, then it could be escalated up where everybody has, I'll just say the right, the freedom of speech, First Amendment. But in Pennsylvania, where you have the right to reputation, could that be brought to the Supreme Court because it only applies in Pennsylvania and maybe I think one other state? But wouldn't that just make it, since it's such a specific thing to Pennsylvania, that they wouldn't even grant cert?
It would be, in my opinion, that if a state has provided a protection that's not in the U.S. Constitution, there wouldn't be any federal claim to make to the U.S. Supreme Court. So of these particular claims here, some of them are resting upon Pennsylvania providing greater protections than the U.S. Constitution does. And the chance, if I'm not mistaken, I remember some years ago that there was a referenda in California that said that the Supreme Court of California could not interpret that the California Constitution provides greater protection than the U.S. Constitution. But if you're going to go into the U.S. Supreme Court, you've got to be asserting a federal constitutional issue. If a state has a provision in their Constitution that's not in the federal Constitution, as long as that state has met the minimums of the federal Constitution, you cannot use the federal judiciary to enforce a state constitutional provision that's not in the U.S. Constitution, in my opinion.
Yeah, no, I think that sounds right. These are, and constitutional law is not my forte, but, it gets a little bit complex.
All righty then, shall we move over to the California corner?
I'd be happy to do that. Maybe clear up some misunderstandings a little bit, because in our little corner in California, people are asking about this new case that talks about reclassifying attempts, and I think that we should talk about that a little bit.
Fantastic.
So I'll be happy to do that. Okay. The status of the litigation in the recent California attempts case is that the California Department of Justice is supposed to be amending its internal policy regarding attempted crime convictions. And I get a lot of calls about this, and so let me start from scratch so that everybody understands it. An attempted crime occurs when an individual intends to commit a criminal act and takes substantial steps towards its completion, but ultimately fails to carry it out. Here are some key points about attempted crimes. 1, specific intent. Attempted crimes require specific intent. The individual must have a clear intention to commit the crime. For example, someone plans to rob a bank or take steps toward it, they have this specific intent for the crime. 2, substantial step. The person must take a substantial step toward completing the crime. The step goes beyond mere preparation and indicates a real effort to carry out the criminal act. Examples of substantial steps include, like, for instance, purchasing tools for a burglary or traveling to the location of the intended crime. 3, failure to complete the crime. Despite the intent and the substantial steps, the individual fails to complete the crime. This could be due to external factors such as intervention by law enforcement, change of circumstances, and so on, or internal factors like change of heart or just fear of accomplishing it. And lastly, punishment. And this is really what we're going to talk about today, because this is what makes sense for this particular issue. Attempted crimes are generally punished less severely than completed crimes. The severity of punishment depends on the specific offense and jurisdiction. In California, Penal Code Section 664 is the designation for attempted crimes. The punishment for a conviction under Penal Code Section 664 is 1/2 of the jail term and/or fine that would have been given if the crime was completed. And this is true regardless of whether your conviction is an attempted misdemeanor or an attempted felony. Now, with that in mind, The bottom line here is attempted crimes are treated differently than completed crimes. So the upshot of the California attempts case is not that all attempted offenses should be on Tier 1. And I want to repeat that again because many people who call me get this mixed up because they've read something or they've heard something about this case being settled and all attempted offenses are going to be on Tier 1 now. That's not what that case is about. It's not about that. It's not that all attempted offenses should be on Tier 1. It's that not all attempted offenses should be placed on the tier that the tier registry law currently places them on. The DOJ's error was automatically, reflexively treating an attempted offense for the same as the completed offense for the tiering purposes. This resulted in attempted offenses that should be on Tier 1 or Tier 2 being wrongly assigned to Tier 3 because the corresponding completed attempt is assigned to Tier 3. The completed offense was there, so the attempt goes there. One can see that I think, if you look at it, the fractured logic of this. If you attempt a crime, then you are arguably as risky as someone who's completed the crime. So we'll treat you all the same under the tiered registry law. That's just really fractured logic. But, that is not how the law works in California, as I've already explained. So most attempted offenses are probably on Tier 1 by default because the tiered registry law does not assign them to Tier 2 or Tier 3. And I say most by default because they're not mentioned. But the major reason an attempted offense would be on Tier 2 as opposed to Tier 1 is because that attempted offense is listed as a serious felony in Penal Code Section 1192.7c. The tiered registry law, which is PC 290D2A, assigns any offense in the serious felonies list to Tier 2. The serious felonies list is long and critically includes not only the listed completed offenses, but also any attempt to commit a crime listed in that subdivision other than an assault. And that's PC 1192.7C39. Now you can check out the seriousness, or you could check out the serious felonies list and see the potentially registrable offenses that, if described, would presumably be in Tier 2. And so, they're taking their time. The DOJ is taking their time in deciding this. Not all attempts are going to be in Tier 1. Some, because they're on that serious felonies list, are going to drop into Tier 2. And for those who really don't know where they're going to fall, you might want to check that list out first. If you're not on the serious offense list, then you can probably assume that when it's all done and things are worked out and the DOJ starts to redesignate, you'll land in Tier 1. Gentlemen, any questions?
I have one. Larry, you can go first if you have one, but I have a question actually for you, Larry.
I actually have quite a few observations. This has been very informative to me. I know it seems people not in California shouldn't think of this, but the reason why you should think of it is because I've been setting up a tiering scheme for New Mexico for legislation that at some point is going to be presented. And I had never thought of how we would deal with attempts in terms of where I would plop them on the tier system. And so this has been very educational to me. Chance, in California, what we do with an attempt is it normally drops at one offense level. Is that the same process in California? When someone pleads to an attempt, it drops it. If it's a second degree felony, it drops it to a third. If it's a fourth degree felony, we don't have anything below fourth degree, so it drops it to a high misdemeanor. Does that work the same in California?
No, we don't have that type of scheme in California. I mean, it's if you're convicted of attempt, it's either an attempted felony or it's attempted misdemeanor. Depending on if that particular conviction's a wobbler or not, it could wobble down, but we don't have degrees and we don't do it that way.
Well, what this has educated me to is I need to think very carefully, because in the plea negotiation and processes that take place, lots of times that is the agreed upon plea as well. Okay, you didn't actually do the event, but you were going to. Will you plead to an attempt? and that drops the person one level in seriousness. Doesn't usually escape registration, but it drops one level of seriousness and severity, which if you violate, it's going to reduce your exposure. And so what's coming to mind to me is I've left out a whole group of people in my own design and I haven't covered. And this is very helpful to me in terms of trying to figure out what we'll do with the attempts.
Very cool. Very cool.
So what
Larry,
was your
my question to you though is,
Yes.
I have heard, my experience primarily rests in the Georgia criminal justice system, that if you are if you're accused of attempted whatever, kidnapping, all of it, like, they're going to treat you just as bad as if you did it. Just because you failed doesn't mean you're less culpable. It just means you sucked at it.
I don't know that I would be completely in agreement with that, because normally the attempted offense is less serious. So even though it's serious, it's not as serious, at least in states I've been more familiar with. The penalty scheme available to the court is less for an attempt than it is for the underlying completed crime.
I see. Well, then I was given wrong information way back in the day.
Well, it's kind of like when you're a co-conspirator. I think you may be thinking more about conspiracies. The person who actually commits the murder and the person who lures the victim to the location, the co-conspirators can both be convicted of murder. But again, in sentencing, there's going to be some difference in treatment on the one who actually did the execution versus the one who manipulated the setup so the person could be killed. But yeah, there's going to be a different outcome, at least in this state, for an attempt versus a completion. Go ahead, Chance.
Yeah, interestingly, and Andy brings this up, this is exactly what the DOJ was doing here. So, if your crime landed in tier 3 and you attempted that crime, it still landed in tier 3. And that's been the problem. That has been a problem. And so, finally, we're getting some movement here to where they're recognizing that these are inchoate or incomplete crimes, and they should be treated differently, just like they're treated in California law, criminal law proper, under the penal code. So we're starting to see that movement, based on the differences between a completed and incompleted crime. And, I think when it's all said and done, you're not going to see any attempted crimes in tier 3. They're either going to be in tier 2 or tier 1. I think the majority will probably end up in tier 1.
Well, you mentioned the term wobbler. I think you explained it a couple episodes back. Would you refresh us? Because I've already forgotten what a wobbler is.
Oh, yeah. In California, there are certain crimes that can be reduced. Now, they can either be charged as a misdemeanor or a felony. And if they're charged as a felony and under certain conditions, which means you don't go to prison, but you are granted probation, you can make a motion to reduce that to a misdemeanor, and that's a rehabilitative motion. And if you do that, there's a good chance it could be reduced to a misdemeanor.
So that's what a wobbler is. All right.
Yes. And if anybody ever wants to check out, especially from the California point of view, what are wobblers? There's a couple of websites and a complete list. You just pop into your search engine, California wobblers, and you'll find them.
So, all righty. Well, we have done this episode in less than an hour, so we can do some pontifications before we sign off.
Very well. Where would you like to go, sir?
Well, I don't have anything to pontificate about. Just give the transcriptionist a break and let's shut it down.
Very well. So on that note, Larry, God, you have like 45 articles here that we were going to cover. But short of that, we'll get to those eventually. Head over to registrymatters.co for the show notes. And of course, leave voicemail. Some people do. 747-227-4477. Larry is literally the only person left that talks on the phone. I will read your emails. What? Go ahead.
I am indeed the only person left, and pretty soon, since I'm 183, I'm not going to be around much longer.
And I will forward your emails. I'm not going to really read them and do much with them. I may laugh at them, and I'll send them over to Larry and Chance. So you can do that over at registrymatterscast@gmail.com. And of course, support us on Patreon, which is patreon.com, patreon.com/Registry Matters. And without anything else, Chance, any final words?
Just thank you for joining us and for listening to this podcast.
Appreciate it very much, Chance. And Larry, anything?
Well, I want to invite everyone that can to join us in our live studio audience in about 3 weeks in Atlanta. 3 weeks from tonight, we'll be recording live with a massive crowd of chanting supporters.
It'll be probably 2 hours from now, too, because it's after the banquet and all that, and that ends 9-ish, and even afterwards, and then by the time I run around and get everything reconfigured. So somewhere about that, in 9-ish or 10 o'clock in Atlanta. Be there, be square.
And we will see if we can raise the volume of the audience above and beyond what we had last time in Houston.
Rocky, I expect you to be there. He lives just down the road. Well, thank you guys very much, and thanks everybody for listening in chat, and I will catch y'all soon. I hope y'all have a good night. Take care.
Good night.
Good night.
You've been listening to FYP. You've been listening to FYP.